move. Please take your seats. Thank you. Caribbean Court of Justice, Original Jurisdiction, CCJ application number 2 of 2018 between David Bain versus the State of Trinidad and Tobago. Can we have the appearances for the court, please? Thank you.
My lords, may it please the court, I'm Patrick Superville representing the claimant, together with Mr. Douglas Ferguson, who is a bit late at the moment, my lords, and I would like to apologize on his behalf. Also, Mr. Ferranlo is not here yet, but Mr. Ferguson has just arrived at the court, so he'll be here in a minute. Thank you, my lord.
Yes.
May it please the court, Rishi Das, together with Sasha Sukram, instructed by Mr. Sean Julian for the State of Trinidad and Tobago.
May it please your honors, I am Sandra Barr, legal officer at the CARICOM Secretariat, and I am being led by Dr. Paulita Bakshifa, General Counsel at the CARICOM Secretariat, and we appear on behalf of the Caribbean community. Thank you.
Yes, good morning, Counsel. Okay. I understand there are some challenges with the noise level in Guyana. I trust that Counsel in Grenada will be able to hear them clearly. Mr. Ferguson?
Morning, Millard. Morning, Millard. And just my apologies for slight tardiness. Millard, would you like to hear us at this point?
We've had the appearances already, Mr. Ferguson. I was inviting you to commence your submissions. Mr. Ferguson, before you begin, just as a matter of interest, how long did you intend to address us for?
I don't anticipate it's more than half an hour. More than half an hour, and that's even subject to questions which the court may wish to ask. But we are relying principally on our original submissions filed in March and our reply to the submissions filed in April.
Yes.
April 3rd, 2019. So we are relying principally on those submissions, and by way of our oral submissions with the leave of the court to emphasize certain aspects of those submissions. But I do not anticipate to be more than half an hour if that's long.
Okay, very well.
And as our starting point, brothers, may I draw the court's attention respectfully to pages 542 and 543 of our submissions in reply filed on the 3rd of April 2019. It's pages 543, 542, and 543. It's the 4th of March. It's the 4th of March. I'm sorry, our submission filed the 4th of March 2019. And more particularly to paragraphs 12 to 20 of those submissions. And if we are to understand the submissions of both the Republic of Trinidad and Tobago and the CARICOM Secretariat, our understanding, based on the questions raised by this honorable court, is that once someone enters another CARICOM country with the passport of a non-CARICOM state, and in this case, more particularly, the United States of America, then that person is deemed to have waived his or her right. And if I may refer in that context to the questions raised by this honorable court for consideration as preliminary questions. And the first question is whether the applicant waived his rights to be treated as a CARICOM community national by the immigration authorities of the defendant state on his presentation of a completed immigration form acknowledging citizenship of the United States of America, along with a valid United States of America passport, thereby invoking citizenship of the United States of America. Now, Article 45 of the revised treaty provides freedom of movement for CARICOM nationals. Freedom of movement, brothers, is the substantive right. It is a substantive right. The issue, as in this case, the first issue is whether or not this applicant is a CARICOM national. And the answer, based on all the evidence before this honorable court, is yes, he is a CARICOM national. There is no doubt of it. He was born in Grenada. He's a citizen of Grenada. He never lost or renounced in any way his citizenship of Grenada. And as was filed last Friday before this court, the 2nd of May, in fact, he is now the holder of a CARICOM passport that was issued on April 18, 2019. And that was merely a renewal of his passport that had originally expired. So here it is, pursuant to the noble aspirations of CARICOM, that CARICOM citizens are afforded the right to free movement. Article 1 of the treaty sets out the meaning of national, and when read in conjunction with Article 32.5a, the applicant meets those requirements in that he is a citizen of Grenada, and Grenada is a member of the Caribbean community. I lay that backdrop with us in a sense to highlight the almost, I'm reluctant to say, but the absurd result that one would achieve, inconsistent with the aspirations of CARICOM, if one were to agree, as it were, with the approach taken by both the defendant states and CARICOM. Because essentially it is almost akin to an issue of strict liability, an offense of strict liability. Either you have your CARICOM passport or you do not have your CARICOM passport. If you do not have it, then you are not entitled to the privileges associated with being a CARICOM national, even though you can establish otherwise that you are a CARICOM national.
But, Mr. Ferguson, surely it is much more practical for immigration officers if you turn up and you present a CARICOM passport, then you're entitled to all the treaty rights. If you don't present a CARICOM passport, then you're not. And the onus is on the visitor to produce a passport. It's cut and dried. It enables the immigration lines to proceed very quickly and smoothly. And there's no need for the immigration officer to try and investigate matters further.
I do agree, Millard, with the expression that once you have a CARICOM passport, it is conclusive that you are a CARICOM national, and therefore entitles you to free passage and the privileges attendant on such free passage. So it is conclusive. But our argument, our submission, Millers, is that it is not the only means of determination as to whether or not you are a CARICOM national. So somebody enters Trinidad and Tobago, you have your passports, machine-readable CARICOM passports, then there are no questions. The immigration officer ought not to look behind the passport to make a determination as to whether or not you are a CARICOM national. But it is a substantive right, my lords, and that right is afforded to not the holder of a CARICOM passport per se, but the issue, the greater issue, is whether or not you are a CARICOM national.
Mr. Ferguson, assuming that we agree with you, would you agree with me that in the circumstances where the entrant does not have the CARICOM passport or does not produce the CARICOM passport, that the onus would then be on the entrant to prove that he or she is a CARICOM national? Would you agree with that?
The onus would be on the entrant.
Yes.
Meaning the applicant, my lord?
Yes.
Yes, my lord, I wholeheartedly agree with that position.
Okay.
I do agree with that position.
So are you then going to lead us to in the argument that your client produced sufficient evidence to show that he was a national of Grenada?
Thank you, my lord, I'm guided. So in this case, the applicant is a dual citizen, and that is allowed. His citizenship of the United States in no way adversely affects his citizenship of Grenada. And he enters Trinidad, and the passport is mere, well, not just convenience, but it is a means to travel from country A to B. And in Trinidad, you also can enter Trinidad with a US passport. In this case, the issue, he is asked whether or not, well, first and foremost, he says, I am, during the course of questioning, he says, I am a Grenadian national.
Yeah.
He says so. Secondly, he is asked whether or not he has anything in his possession that can prove that he's a Grenadian. And his answer to that question, of course, is yes. He thereafter produces, one, a driver's license, his Grenadian driver's license, and that driver's license says he's a Grenadian, his place of birth is Grenada. It says so on the face of it. He thereafter produces what we refer to as a national ID, also, well, more specifically, a voter registration card. And that voter registration card says his place of birth is Grenada. So he produces two independent pieces of evidence that says to the immigration authorities that I am a national of Grenada.
Mr. Ferguson, I follow you. You mentioned three things. One, that he was a dual national
Yes, sir.
of two countries, the driver's license and the voter's card. Can we eliminate the voter's card as proof conclusively that he was in fact a Grenadian? Does it say anywhere on the voter's card that he was in fact a Grenadian?
It says his place of birth.
So, Mr. Ferguson, it really boils down to this. Whether the border official of the receiving state is entitled to rely on the oral statement of the entrant plus two government-issued documents which show that the entrant was born in the relevant CARICOM state. Would you agree with that?
That the issue, sorry, I missed the opening.
Your argument boils down to this, that
Yes.
the border official of the receiving state should be satisfied on the basis of A, the oral statement of the visitor, that he's a national of Grenada, plus the production of two Grenada government-issued documents which show that the visitor was born in Grenada. Those are all the pieces of evidence that would have been adduced to satisfy the Trinidad border official.
Right. And there was a fourth bit of evidence, which was his US passport, which says that his place of birth was also Grenada.
Right, and the U.S. passport that said that, you're right, that his place of birth is Grenada.
Right. But I would not put it as far as saying should be satisfied. What I would say that the owners having not produced a CARICOM passport, then the owners would be on the applicant to establish that he's a Grenadian citizen.
Yes.
Having produced those bits of evidence, if the Trinidad immigration authorities are not satisfied that these four independent bits of evidence establishes that he is indeed a Grenadian national, at least it is enough to put them on notice that this gentleman is a Grenadian national.
But Mr. Ferguson, all those three documents do is to establish that the gentleman was born in Grenada. That is all that they do.
Or did you state earlier the driving license on its face actually said he was a Grenadian citizen?
Yes.
The driver's license says his nationality is Grenadian.
That's right, yes.
Yes.
That is, that's Exhibit DB4, is it?
Yes, my lord. Maybe Mr. Superville is just finding a.
What page is that?
So,
Yeah.
But that is
My brother Justice Witt was pointing out that that driver's license, and we agree with you, it does say on its face that he is Grenadian, but that driver's license was issued in March of 2018. So he could not have produced that driver's license to the Trinidad and Tobago Immigration Authority. The incident occurred in December 2017, and this driver's license exhibited was issued in March 2018.
yeah, it was renewed then, my lord. It's not the same. It's just to show as the submissions from the state of Grenada.
No, but I'm sorry to interrupt, but to be relevant to the inquiry, surely you have to reproduce the driver's license that was exhibited to the TNT immigration officer.
Yes, that was, but by the time, my lord, that license was expired in the case management.
It doesn't matter. It does not matter. You have accepted your client as the onus of proving to the Trinidad immigration officer that your client was Grenadian. So I think you have to produce to us the evidence that your client presented to that officer, surely.
Yes, my lord, and we did indicate that, may I just crave the court's indulgence momentarily? Yeah, just a minute. Yes, he did give the copy, the original copy that bore the material date of a valid license in December 15th. He did present. The challenge, my lord, is that the one that is produced now is the renewed copy, and as indicated in the case management conference that before.
Put the matter another way, Mr. Ferguson. Sorry, I understand. Put another way. Do you have the concession from the defendant that the driver's license produced to them contains the same information as that you have exhibited to us?
Yes, that's not an issue as far as I am aware.
Okay.
Yes.
Okay, so then you see, I want to get to the kernel of the case. It boils down to whether the production of a Grenada driver's license that states on its face that the holder was born in Grenada and his nationality is Grenadian, whether that is sufficient to trigger the enjoyment of the right of free movement of that, the holder of that driver's license. Am I correct? Because clearly I don't believe that you would seriously suggest that a document, whether issued by the United States government or the government of Grenada, that says the person was born in Grenada is a sufficient document for this purpose. The mere fact that you were born in Grenada, whether 30 years ago, 50 years ago, does not necessarily mean that you are of Grenadian nationality at a particular point in time. And therefore, the only document which really is relevant as far as I can see is the driver's license that says on its face that his nationality is Grenadian.
The other problem, Mr. Ferguson, is that immigration officers are used to looking at passports and know what passports look like, and passports are relatively difficult to forge. Immigration officers are not au fait, I would have thought, with voters' registration cards and driving licenses, which I assume are much easier to forge than passports. And an immigration officer has to think about security when people are coming into his country.
Yes, Philip, but may I say in the context of this case, within the factual matrix of this case, this was never an issue. This has arose as a preliminary point, but as would be seen in the substantive arguments before this court, that the issue of his place of birth, his nationality, was not the reason, or did not form the basis at all of his being sent back to Grenada. He was sent back for other reasons. And it is the immigration officer who asked him whether or not he was a citizen of any other country. And his response, yes, I'm a citizen of Grenada. And it is the immigration officer who asked whether or not he had any evidence to establish he was a Grenadian. He produced that evidence, and without more, as the rejection order would show, he was sent back to Grenada on the basis, allegedly, that he had these convictions pending in the United States of America, and that there was a warrant supposedly out for his arrest. That was the reason why he was sent back. The reason why he was denied entry had nothing to do with his nationality at all.
No, but you see, we haven't heard evidence on this matter as yet, so that, the factual situation, I'm not sure how much of it is admitted, the sequence and so on. What we wanted to hear today is arguments on what documentation is necessary and appropriate in order for a receiving country to be satisfied that a visitor is entitled to the right of free movement under the treaty. So, again, I try to bring it back to its essence. It seems to me that your case is that strictly on that legal issue, a driver's license of Grenada that says on its face that the holder is born in Grenada, was born in Grenada, and is a national of Grenada, that is a sufficient document as far that satisfies all the necessary legal requirements. Because I am putting to one side a U.S. government-issued passport that says he was born in Grenada. To my mind, that is not a sufficient basis and cannot be a sufficient basis to say that he is, at the time that passport is presented, a national of Grenada, because he could have renounced his nationality. Nor, to my mind, is a document, a voter registration card, saying that he was born in Grenada, because again, it would require the immigration official to have to dig up and search and investigate as to whether he has renounced or has lost that nationality between the time it was issued and the present time. So the document which I think you would be relying on is the driver's license. So that perhaps if you could tell us, well, why should that be a sufficient document for this purpose?
I do accept that the driver's license, as compared with the three documents, is a document that expressly says his nationality is Grenadian. I also wish to place in the factual context of this case that this is not a situation where the applicant was in line with several people waiting behind while this matter was being determined. He was on the airport for several hours.
Mr. Ferguson, we don't want to interrogate the facts. We just want to zero in at this stage on the legal issue of what documentation is necessary and appropriate in order to trigger the rights under the treaty.
Yeah, but I would say certainly, my lord, the driver's license, because it establishes that he is a Grenadian national and it was a valid driver's license at the time. But I say further, and that's the reason why I put in context outside the line, because obviously there was further investigation taking place. And a simple phone call to the immigration authorities of Grenada, the applicant having triggered the process by saying, I am a Grenadian, and producing a Grenadian license, together with other documents, a simple phone call to immigration in Grenada could have determined that question. And it is in that context I made the point, because Justice Hayton did indicate that, and I agree, that immigration officers are accustomed to passports. There's a long line. You are servicing a line, and therefore you do not have time to deal with these issues. So I'm saying those documents were sufficient in the event of any doubt to trigger at least prima facie that this applicant was a Grenadian, and to trigger further inquiry on the part of the immigration authorities to confirm by a mere phone call that he was a Grenadian citizen. Because under the treaty, the right is accorded to nationals of the Caribbean community.
Yes.
Yes, and if I may draw attention to page 503, paragraph 20 of page 503. And that's of the criminal submission. I would say disrespectfully, 20A and B captures the applicant's position that the U.S. passport used by the claimant, combined with the presentation of his Grenadian driver's license, his Grenadian voter's ID, was sufficient evidence to establish that the claimant was a Grenadian citizen. Once the claimant established that he was a Grenadian citizen, he was entitled to be treated by the defendant as a CARICOM national.
Wait, just a minute, you're reading from page 503? 543.
So 543, I'm sorry, brother.
Yes.
Paragraph 20. Page 543, paragraph 20. And that's 28,
Yes, we have it.
right, 28, and then 20B, alternatively, and this captures our position, that the claimant produced sufficient evidence to put the defendant on inquiry that he was a Grenadian citizen and hence entitled to be treated as a CARICOM national. Once the defendant was placed on such inquiry, it was under an obligation to make reasonable inquiries to confirm or refute the claimant's Grenadian citizenship and entitlement to treatment as a CARICOM national. But we say this is a substantive right. And if the position is taken, for example, that mere travel on a US passport waives that right, then what it means is that if someone forgets his or her passport, misplaces it, and enters a territory as a dual citizen of a CARICOM state, then that person, by the mere absence of the passport or the documentation, would not be entitled to be treated as a CARICOM citizen, even though evidence prima facie points to such citizenship. And the license does indeed so far. And as I started, so I propose to end.
Before you consummate the proposal, Mr. Ferguson, could I just ask you about 20 paragraph B?
Yes, Lord.
Yes, you are saying that provided there is the production of sufficient evidence, the defendant is put on inquiry. And there's an obligation, you say, on the defendant to make reasonable inquiries. Now, those reasonable inquiries, I assume, would include telephone calls, for example, from Trinidad to Grenada, as you said earlier?
Yes, I would say a single telephone call to the immigration department.
So what if it's a Sunday evening and the department is closed?
Sorry, my lord?
What if it's a Sunday evening and the department is closed?
Well, then in those circumstances, Monday morning comes and the call can be made.
And where is the entrant? Where is the entrant between Saturday or Sunday and Monday?
But where he was kept originally, he was kept in the waiting area, in the open area.
And you believe that would be appropriate?
To keep him there in the circumstances, I would say, yes, my lord, if the authorities are not satisfied, he has come to Trinidad for a specific purpose. He has expended monies to do so, and it would be much more convenient if an issue needs clarification to clarify then.
So let's extend the thought experiment a bit more. Let's say he arrives on Friday afternoon. You're saying that he should be kept in the waiting area until Monday morning at 8 o'clock when the call can be made. Is that what you're saying?
Well, my lord, if I may say, with technology, these issues can be established. I would respectfully.
Do you know whether the Trinidad immigration authorities have the technology that you have in mind?
Well, certainly I would say yes, and it's borne out in this particular case because the substantive reason for sending him back, it was as a result of an email sent that he was on a plane that was traveling after 10 in the night.
Yes.
To arrive in Trinidad before midnight.
I understand,
And
but
according to the defendant,
Mr. Ferguson, sorry to interrupt. I do understand what you're saying. I'm just inviting you to see the difficulties that can arise where the entrant does not produce what CARICOM calls the appropriate document, i.e. the passport. Because if you don't produce it, you have a situation where if a call is to be made, it might not be possible to make that call for some time. The other question is, of course, who bears the expense of making these, what you call, reasonable inquiries?
Milord, he is a subject of the state, well, a subject of CARICOM, we respectfully submit. And in circumstances where it is not unreasonable to conclude, based on the documents he has presented, that he is indeed a Grenadian national, in those circumstances, Milord, it would not be asking too much, I respectfully submit, to make such.
Well, no, but what you're saying comes within 20A, I think. So he has established that he is a Grenadian national. But in circumstances where he has not been able to establish that, you're saying that reasonable inquiries must be made, and I'm just wondering where that might take us and the mischief that that could take us towards.
Yes. What is reasonable would depend on the circumstances of the case. This applicant spent over 5 hours in Trinidad. He was there for over 5 hours, indicated that he had come for a wedding. He came for a few days, and actually for about 10 days or thereabouts. And he came on a flight late in the night. So he was kept there. And what is reasonable would wholly depend on the circumstances of the case. But I would take it that the free movement of CARICOM nationals being a substantive right to be enjoyed by nationals. If someone says, I am a national, and there is some doubt, it's not just dependent on an oral pronouncement, but on actual documentation, which seem on the face of it to support what he's saying. Yes. But if the receiving country is still doubtful, I would say, even in the face of that evidence, some others may accept it. But if doubtful, I would say that it is not too much for the state in those circumstances to make an inquiry.
On the other hand, Mr. Ferguson, can't a state take a reasonable view and say, well, look here, the onus is on applicants to establish where they come from. When in doubt, throw out or keep out. It's simple enough to just bring your CARICOM nationality passport. There it is, you're in line, you present it, you're through. And if you don't do that, well, then it's your fault for not taking advantage of your rights by producing what's required to exercise the rights.
That would be unduly harsh, is my respectful response in the circumstances. And if I may, just to draw a parallel with even driver's license. You may be driving, and the driver's license is what says that you are validly on the road. You would have passed the requisite exams, and but it must be valid, it must be current. If you are stopped by a police officer and you are unable to produce your license, then you are given days within which to do so, 5 days to produce it. Because it's not that if you represent, you have one, then find it and bring it in. In this case, all he's saying, yes, I'm a CARICOM national. I was not bargaining for all of these issues when I entered the Republic of Trinidad and Tobago. I expected a smooth passage as before. I happen to have used my my U.S. passport, not because I waived my right to be treated as a CARICOM national, but it happened at the time my Grenadian passport had expired. So he did not waive his right. He used the passport to enter Trinidad. When he was faced with problems and the issue of his nationality arose, he then says, well, I'm also a Grenadian national, in response to their questions. So it was not a situation even where the Trinidad and Tobago authorities believed him to be a U.S. citizen and therefore just left it there without more, in which case it would have been his duty to say, well, listen, I'm a Grenadian too. But they asked the question, and he responded accordingly. So I'm saying it would really be unduly harsh. And our respectful submission is that it could not have been the intention of the leaders of CARICOM for simple citizens who travel from country to country in circumstances where they cannot produce a particular document in a CARICOM passport. So automatically, which is what these submissions say, denied entry and denied the privileges of what is supposed to be a substantive right. And I would also add that there is no way in the treaty which suggests that. The treaty says, plain and simple, if you belong to a CARICOM nation, you are national, then you are a CARICOM national and you are entitled to those substantive rights. And as we indicated, between our paragraphs 12 and 19, pages 542 and 543, that there was a conflating here of the substantive right and the procedure of form, substance versus form. Because in this case, the approach of the Republic of Trinidad is to say, once he produces, and that's the issue, once he produces a passport of a non-CARICOM country, then he waives his right. And that issue of waiver is fundamental in our view. Because the waiver would suggest that he is no longer, for example, if he renounces his Grenadian citizenship, then he would have waived his right to be treated as a CARICOM national. Because through his own voluntary act, he would have chosen to renounce his citizenship. In this case, he is traveling on a passport out of mere convenience. So we invite the court respectfully, Millards, to pay particular attention to paragraphs 12 to 19 of our submission, the issue of substantive right versus form. And we say, in conclusion, that all CARICOM is suggested by way of a machine-readable CARICOM passport and CARIPass is to make travel more efficient. Not to deny it's a citizen, a national of another country, the right to travel freely in the event that neither of these two documents, for whatever reason, is available at the time of landing in a fellow CARICOM state.
Yes, Mr. Ferguson, you referred to Article 32, paragraph 5A2 of the treaty, saying that that would say that a resident of a state is also to be treated as a national. That's on page 541 of the record at the bottom. And you react there to something the defendant state has said in paragraph 46 of their submissions. But you also saw the, I suppose you saw the submissions of CARICOM and the evidence they submitted. And they are saying, well, that particular part of the paragraph only relates to Montserratians. So it doesn't mean that if you're a resident in a CARICOM country, although you are not saying that your client was a resident, he was a national, but even a resident of a CARICOM country does not, if I understand CARICOM correctly, does not have this freedom of movement. Can you say something more about this particular point? What is exactly, why do you refer to this, 325A2? Can you?
Yes.
Yes.
But in our respectful view, Millard, we do not share the interpretation advanced by CARICOM. Those subsections are to be read disjunctively in our view, and one, we are depending primarily on the fact that the applicant is a CARICOM citizen. But it goes further. It goes further to state in sub 2 that even if you are not a national, then you are still entitled to be treated as a national.
You mean even if you're not a citizen, even if you're not
even though you are not a citizen.
Yeah, you can
Right.
still be treated as a national, you're saying?
Yes, 2, subparagraph 2, that you can still be considered in the circumstances. What I would, my short answer to that point is that no way on the face of it, on the treaty itself, that that it says that those exceptions relate to Montserrat alone. And if that was the intention, then our respectful view in that document, it should reflect exceptions to that particular rule. And if I may invite, even in the context of that particular point, refer to paragraph 7 of the original submissions of CARICOM, and that's contained at page 367. Paragraph 7, which says, at the 26th meeting of the Conference of Heads of Government of the Community, the conference, and it went on to say, agreed that the CARICOM passport as page 367, submissions filed on the 18th of February 2019 of CARICOM.
So which part do you highlight here?
Paragraph 7. It says, at the 26th meeting of the Conference of Heads of Government of the Community, the conference agreed that the CARICOM passport would be accepted as evidence of community nationality, and as such evidence of entitlement to right. It does not say it is the sole source of evidence. It says it would be accepted as evidence, and I would add conclusive evidence in those circumstances.
Yeah, but that doesn't answer my question.
Sorry.
The question is, why is 325A2 relevant in your submission? You're saying we do not agree. We do not agree with CARICOM that it is only limited to Montserratians, because in that case they would have said so, or they would have made it an exception. And then you wanted to show me something in this respect. So what is it that you want to highlight?
So I'm saying in relation to 582, is that what it merely shows is that even the treatment as a CARICOM national is not confined solely to citizenship. That is what we are saying in relation to 2. In this case, the applicant is a citizen. But what we are saying essentially is that 5.2 even takes it outside of the realm of citizenship and allows for persons, and I'm just actually as I speak trying to get the exact wording of the section, but it essentially says that even, and I'm just paraphrasing, that even though you are not a citizen of a CARICOM country, you can be still entitled to be treated as a CARICOM national. Once you are resident and the other factors. I don't have the exact wording, I must confess.
Well, Mr. Ferguson, I'm not sure how much we need to go here because, as you said, your case does not depend upon it. And secondly, I think that, with respect, I'm not sure that you're reading the provision in the context that it was meant to be read in. You know, the provision talks about if it be so expressed that's in the legislation. So there is a way, I think, that if you read the provision in 32.5A2, it is not saying straightforwardly that if you are not a national but a resident, then you can be treated as a CARICOM national. I think some more interpretation needs to be put into that. Yes.
And in any event, it would be wholly unreasonable to expect an immigration officer to find a person to be a national under 582. It would just be impractical because 582 seems to require some kind of investigation of the nature of the connection.
Yeah. And of the national law, you'd have to
Right.
say the national process.
Right. Yes, and if I may say, whatever may be the confusion initially caused, what the point was made not to, with the expectation that an immigration officer would actually conduct that inquiry, but it was simply to make the point that even treatment as a CARICOM national is not confined merely to citizenship. And in this case, the applicant satisfied the citizenship requirement. So it's not a section that we are relying on, because in this case, the primary consideration was whether or not he's a citizen of a CARICOM country.
Yes, I think your submissions are very nicely summed up in your conclusion on page 543. So we have that and we will consider them. Is there anything else?
Thank you, much obliged. If there are no further questions or clarifications, those are the applicant's submissions.
Yes, thank you.
Much obliged.
Yes. Mr. Das?
I'm grateful, my lords. Subject to any direction that you give me, I don't propose to go through my written submissions, which I take it that you will have read. Yes. So my learned friend said that he would be half an hour. He was a bit longer. I hope that I will be no more than that. I think subject to any questions that you have. If I could just begin with a number of submissions that my learned friend made today, which is that he said that an absurd result would occur if you were to require that a CARICOM passport be produced. He did not really explain what the absurd result was. What he did say was that if, for example, you misplaced your CARICOM passport, you would not be entitled to enjoy the rights. But we say that's not absurd. That makes perfect sense. And in fact, if you contrast it with a person who had single citizenship, they wouldn't be able to fly abroad with a passport. So why should there be some finding of absurdity merely because somebody had misplaced their passport? I mean, in this case, the evidence is now that Mr. Bain has obtained a valid CARICOM passport, which leads to the inference, I think, that his decision not to maintain a valid passport was really an election on his part. He had he had a former passport, I think his evidence was, that he did not have with him at the relevant time. That seems to be a choice that he made because
So he deprived himself of his
precisely.
rights.
So that there's really no hardship that he could legitimately complain of by electing to travel on an American passport. Secondly, my learned friend said, for the first time today, he said that, a simple phone call to Grenada could have solved this problem. But first of all, we point out that there is no evidence to that effect. But what evidence there is before you actually suggests to the contrary. If you look at the submissions that are helpfully put in by the state of Grenada, they say a number of things that are relevant to this issue. The first thing that they say is that, well, with respect to the driver's permit saying that he's a Grenadian national, they point out that there's no requirement in Grenadian law for to have any citizenship to obtain a driver's permit. And that's at their submissions at page 414. So that the inclusion of nationality appears to be a sort of an additional or gratuitous inclusion. But it's
Yeah,
not
but even if it's gratuitous,
yes.
is it to be ignored? And if so, why?
Well, that will lead me to my second point, which is that what the state of Grenada says further is that they say that for themselves to determine nationality, they don't look to the driver's permit. In fact, they don't make a phone call to the immigration department. And that's at their submission. They say at paragraph 11 of their submission, that's at page 415 of the record, they say, in the case of the claimant, we checked with the Ministry of National Security, Public Administration, Home Affairs, and Information Technology, which is the appropriate department in Grenada, and found that he had not renounced his citizenship. That's what they had to do, because there was no valid passport. So to suggest, as my learned friend says, well, we could have made a simple phone call, is simply not borne out on the evidence in any respect. Moreover, and I think my Lord Hayton had raised the point about security. Moreover, there is before you a number of documents dealing with the very detailed efforts that have been entered into by CARICOM to establish security in the region. And one of those things is the CARICOM Impact Strategy. And one of the important aspects of that, which is at page 299 of the record, is they talk about the APIS system, the Advanced Passenger Information System, which anybody who's taken an international flight is familiar with. You're asked to log in, if you check in online, you're asked to log in and fill the particulars of your passport out. And that's because internationally there is a great deal of collaboration between states with respect to passport standards. That's why there's a push internationally for machine-readable passports. And this is what CARICOM was saying in their regional strategy. They were saying we need to have strategic lines of actions to expand the use of APIS. And at paragraph 417, they talk about improved maritime and airspace awareness, and a strong border is essential in protecting against transnational organized crime, etc. It's vital that risks are flagged before they arrive, which requires risk management tools, etc. And just for completeness on that page, paragraph 7, they talk about CARIPAS, which I'll get to in a minute. But what that shows is that there is an effort, a quite detailed effort between the member states of CARICOM to harmonize and liaise between their respective security systems to establish how we allow entry into our countries. And what the effect of my learned friend's submission today is that we could make a phone call to the immigration department and short-circuit that system without a valid document. And that seems to me an absolutely untenable suggestion, because that would undermine all the efforts of CARICOM impacts and their attempts to establish security at their borders. Now, we respectfully say that when you consider how the treaty is to be interpreted, that the starting point has to be that the member states would have expected that the invocation of citizenship by a citizen of a member state would have been done in the traditional and internationally respected manner, which is by a passport. And if there's to be any derogation from that, it would have to have been specifically spelt out. And we say that as a general principle of interpretation of the treaty.
But, Councillor, would you admit that there is no requirement in the treaty?
No, there's not.
Okay.
There certainly isn't. However, when you construe the treaty, I would suggest to you that you are permitted to look at the negotiations which CARICOM has put before you, the state, in their submissions, as to how the heads of government negotiated. And you are entitled to look at the terms of subsequent treaties like CARIPAS, which also show an understanding as to how this was to operate. Because, of course, if the suggestion or the submission of my learned friend is accepted, that, in fact, you could have this entire secondary category of documents that could act in substitution for a CARICOM passport, it would, in a very real sense, render the quite detailed provisions of CARIPAS otiose. And when you look at CARIPAS, you'll see, and I'll take you to it in a little bit of detail, you will see how extraordinary the requirements are. In the first place, you have to have a passport. And even having a passport doesn't entitle you to a CARIPAS. You still have to be subject to a security vetting. To suggest that all of that could be put to one side merely because you raise a duty of inquiry by producing documents that don't establish citizenship, even if they may record it, would be to put the entire CARIPAS strategy on the back burner, which I don't think is a legitimate reading of the revised Treaty of Chaguaramas. You know, I mean, it's a matter of pure pragmatism. The invocation of any right doesn't exist. There's no state of perfect knowledge. The invocation of a right requires some sort of modality to be successful. And I think our submission is, my lords, that the entire international body and practice of passport law suggests that that was the background that was contemplated by the revised treaty. We had sent a late authority, my lords. I don't know if it's come before you as yet. That's the case of Brailsford. I know it was circulated on the e portal. I think really just one passage in it that we rely on, which states that it is well to consider what I think I've just highlighted it, and I apologize for that. We only have one hard copy here.
It's at page 558.
My lord, I'm afraid I don't have the actual digital copy, so I don't have the number of the actual. But it's up on the board if that will help.
But it's a short case.
It's a very short case, my
5
lord.
pages.
And it's at page 5 of the internal numbering. It's the second to last page, my lord. I don't know if that helps.
So it begins what? It would be well to consider what a passport really is.
Yes, that is the passage that we rely on. I'm grateful. I tried to help, and I think I turned off the machine. Okay. It's well to be considered what it is. It's a document issued in the name of the sovereign on the responsibility of a minister of the crown to a named individual intended to be presented to the governments of foreign nations and to be used for that individual's protection as a British subject in foreign countries. And it depends for its validity upon the fact that the Foreign Office is an official document and vouches the respectability of the person named. Now, my learned friend says we've not established a waiver. Now, the use of the word waiver, I think it comes from the court's formulation. In our actual preliminary point, we had used the term that he had not invoked it. I don't think there's a world of difference between those two things. But waiver, in a sense, brings a sort of a baggage from private law that my learned friend has relied upon in his submissions. But at the end of the day, if my learned friend attends the Trinidadian port of entry and presents a passport saying that he's an American citizen, and he's traveling in that capacity.
But surely if, let's say, he would be refused on the grounds that were used,
Yes.
and then he would have said, oh, but here's my Grenadian passport.
Yeah, well, then that would
would
have
be a
changed.
different.
It would change entirely, because
Yes.
of course he would have then had a document espousing his nationality, and in a sense he would have then switched the means by which he'd entered.
yeah.
And I suppose, I don't know the practicalities, but I imagine that he would fill out another form, I suppose, to say that he was using a different passport for entry.
Yeah.
And that's the document, that's the passport that would then be stamped upon his entry instead. So that would be an entirely different situation. I accept that.
Yeah,
Absolutely.
because as a non-CARICOM citizen, you can be refused anyway.
That's right. So, I mean, the specific grounds upon which he was refused in this case are not really relevant because he had no entitlement to enter if he was not a CARICOM citizen, which I think is why the court framed the issue as it did. Now, my learned friend then has now pivoted slightly, and he says now there's a duty of inquiry. But if our primary response to that is that no, there's not. The onus is on him, and he must establish it. He must establish nationality by some document. I mean, a passport just, the law on passports is that it's not dispositive of nationality, because a passport could be procured by fraud, for example, but it is really the best evidence in international practice of nationality. But whether there's another means of establishing it's not the issue specifically before you. The issue before you is really whether he had sufficiently established it by means of the 3 documents that he did produce, which was driver's permit, national ID card, and American passport. We say that plainly birth is not a sufficient ground because you could have renounced from the time you took citizenship.
Sorry, before you go there,
Yes, my lord.
could you just perhaps expressly respond to that point? Are you conceding that he could have established his Grenadian nationality by means other than a CARICOM passport?
Well, like I said, my lord, I don't think it arises before you, so I'm not in a position to give a concession. I'm not conceding the point as a matter of law. But in my own research, I've seen, for example, the state of Grenada can in their domestic legislation.
I'm not sure you say why it doesn't. I'm not sure why you say it doesn't arise before us.
Well, my lord, because the issue before you is not the academic issue about whether a passport's the only means. The issue before you is whether he has established by means that he did produce, which is driver's permit, whether that was sufficient is a specific issue before
Well,
you.
but that's the question. The question is, can he?
Not
prove
could
his
he do
nat-
it by some other document, my lord, is the point I'm making.
I'm sorry.
Not whether he could do it by production of some other document that he didn't produce. That's not before you. What's
Okay.
before you is whether he did establish on the documents that he did produce. That's what that in that narrow sense is what I mean. It's not
Oh, I
before
see.
you. Yes, my lord. For example, the state of Grenada, their immigration legislation, I think, provides for the minister to certify nationality in certain cases. Now, it's arguable, I suppose, that maybe between member states they might accept that. I don't know if it would meet the threshold for passport and international travel. That would be a question, I think, to be determined on a case-by-case basis. That's why I say it's not strictly before you.
Or
Because I don't know
perhaps
that
if he
all-
had produced an OECS laissez-passer.
Yes,
Again,
well,
that's arguable, but it's not
arguable
before
as well.
us.
And I think in the manual of Trinidad that we had produced, that's in the pleadings, for example, that is referred to, the laissez-passer. So there may be other documents that would each have to be, I think, decided on their own facts, particularly. But
Either
so,
CARICOM laissez-passer, where that would be clearly
yes.
permissible.
And again, it goes back to the purpose of a laissez-passer, which is to facilitate travel in a sense. And that's one of the other answers that we have.
Yes, but I think if we agree that he does not have a travel document
Yes.
in the sense of a CARICOM passport or the passport of a CARICOM state, the question I'm still grappling with is whether in the abstract or not, can he prove his CARICOM nationality by reference to another document? I'm still sort of trying to understand your response. I think you're saying yes, he can.
My lord, I don't think it arises on the case, but I suppose it is
But
conceptually
satisfy my
possible.
curiosity
Yes.
whether it arises or not.
Yes.
Tell me, can he prove his Grenadian nationality by other means?
My lord, I would have to, insofar as the law on passports is that it's not dispositive, I suppose, I mean, if there was a declaration of this court that someone was not a stateless person, but a person under the treaty entitled to it, and he produced that, but not yet a passport, then maybe, maybe arguably, that there might be other means by which it could be done. What if there was an order of court in Trinidad saying that this person was a CARICOM citizenship, and he produced the order and a mandamus
Yes.
to the immigration department, possibly.
Birth certificate?
Sorry?
Birth certificate.
No, birth certificate, absolutely not, because of course a certificate could be, it's merely just to certify the geographic location of birth.
Yes.
And it goes back to the purpose and nature of the document, which was the point that I was addressing in answer to the President, which
Yes.
is of course that a laissez-passer is for that purpose in a sense. And that's
Yes,
why it
but-
would certainly be legitimate.
But I think we have passed that. We have conceded he doesn't have the appropriate travel document
Yes.
to prove CARICOM nationality, but we are wondering whether other documents, travel documents or not, in their totality,
Yes.
can result in a decision that yes, he's a CARICOM national.
And that's the point I am addressing, perhaps a little
Yes,
desultorily.
no,
But I
that's
suppose
it.
your narrow point is that the reference to his Grenadian nationality in the US passport is not enough, even though supplemented by the driving license statement on its face.
Yes.
Or by his state of birth on the electoral registration card.
Yeah, that is essentially.
But you'd agree that these pieces of evidence are relevant? They're not conclusive.
I don't know that
Perhaps.
they're relevant either, because
Not
and
relevant.
it must be seen, again, from the point of view of an immigration officer at 11 p.m. in the night in an airport. What are they supposed to do with a driver's permit? These are different countries. The immigration department in Trinidad and Tobago doesn't have a direct line to the driving registration authority in Grenada or Jamaica or any other island. So there really is no position. It's very easy to say duty of inquiry placed upon you, but how is that supposed to be practically expressed, articulated? It is, in our view, a completely untenable suggestion that an immigration officer at the gate could have the means, the authority, or the capacity to undertake that type of investigation. In fact, even CARICOM impacts, which allowed this particular person, Mr. Bain, to be flagged, was a result of an enormous amount of actual liaison between the states, which is the CARICOM Impacts Treaty and the establishment of a body. That's how this was facilitated. So to suggest that it could be undertaken on an ad hoc basis between different nationalities is, I think, unrealistic. So in that sense, I would say it's not relevant, because there could not be any legitimate investigation that could have been carried out at that case. I mean, put another way, suppose this immigration officer had a hunch and thought, well, this is a good idea. I think this is legitimate. Could they have allowed entry on that basis? I imagine they would be disciplined in the morning for doing that. But I think it has to be viewed with a healthy degree of pragmatism in the context of national security, regional security, and the means of resolving these issues on a regional basis by the heads of government who have done it. I mean, imagine, when you look at the impacts document, for example, you will see that there's a healthy degree of collaboration between the immigration authorities themselves. So it means that there is training, and there is a filtering down of that regional move to try to coordinate. And to suggest that they could go outside of that seems to me to not be an appropriate response. And certainly not one that could be an entitlement, as Mr. Bain would have to convince you, an entitlement under the treaty. So, my lord, I hope I have answered that.
Yes, you have, thanks.
I'm grateful. My lord, I note as well that the issue of IDs or lesser documents were the subject of specific heads of CARICOM meetings. And we've referred to them in our submissions. And you'll see that national security issues were raised. Security issues with photo IDs were raised and discussed in those meetings. And they still resolved. Even then, that they concluded that machine-readable passports really should be the basis. And that represents a political will of the states as to how they're going to manage this issue. And I would suggest that it ought not to be interfered with lightly or in the absence of express language to the contrary in the treaty. And that, my lord, is also underscored by Carapace, which I will not take you to, I've touched on before, which was that it had to be subject to security. A sine qua non was a passport, first of all, so that Mr. Bain could not have obtained a Carapace even at the relevant time, even if it was operationalized. Secondly, it was subject still to security vetting, which meant that if you wish to embrace or enjoy the benefit of a more flexible admission procedure instead of a passport, you had to go through a heightened security process. That was the view of the member states in Carapaz. And thirdly, even with all of that, even with the establishment of impacts and their input, even then, the Carapaz system's not yet operationalized, which suggests that there may be concerns on a political level, whatever they may be, moving this forward. So certainly it ought not to be moved forward through a judicial order, through a reading in under the treaty, unless it was absolutely clear that those rights were vested under the treaty, so to speak. So, my lord, ultimately, we say that this case is only about modality. My learned friend says, there's a conflation between modality and substantive rights. We say there's not. No one has suggested for a minute that Mr. Bain is not a Grenadian citizen, or that he should not be entitled to enjoy all the rights that flow from that. No one is suggesting that. No one is suggesting that, as in my read, that this is a pattern of behavior on the part of the Trinidad government in not honoring its obligations. None of those things are before you. This is a far more prosaic issue, which is about how these rights are to be legitimately invoked. At the end of the day, Mr. Bain elected to maintain a US passport. He elected to fly upon it. He elected to not maintain a valid Grenadian passport. And for that election, he wants damages. I think in his pre-action, he said he wanted $25,000 US as a result of that. We say that there should be no entitlement and there is no breach. It is entirely consistent with the revised treaty for people to have a passport to invoke their rights. It's entirely consistent with the approach of the heads of government in successive meetings, as CARICOM itself pointed out, and it's entirely consistent with the subsequent treaties that this is how it ought to be done. And we say that there could be no legitimate criticism of the Trinidad government or the receiving officers of immigration. I should point out that Mr. Mohammed, who I should have announced earlier, from the Immigration Department, is here, as they have keen interest in as to whether their actions are defensible or not, as you can imagine. And so we say that they acted properly in all the circumstances. My lords, unless there is some further matter, I think I will... my lords, unless there's anything further, I will. I think I can conclude. I will.
No, that's,
I'm very grateful.
Yes, thank you very much. CARICOM, you wish to make any submissions? Ms. Schaefer?
Yes, Your Honor, briefly. The applicant has said that he has in his answer that he has right of freedom of movement. But freedom of movement is not an unbridled right. It is a right that must be balanced with adequate security measures through a secure and trusted system.
Ms. Schaefer, it's breaking up a little bit. We're not hearing you very clearly. Maybe you should sit and let us see whether the reception is a little better while you're seated.
Thank you, Your Honor.
Yes, that's much better.
Thank you. The applicant had said that there's a right of freedom of movement under the treaty. But freedom of movement is not an unbridled right. It is a right that must be balanced with adequate security measures to protect the security of CARICOM member states, to protect these member states. As my learned friend noted, and then my learned friend from the state of Trinidad and Tobago, at the 10th special meeting, the conference had before it acknowledged that Guyana and other member states had accepted photo IDs. Nevertheless, the Council accepted a recommendation that the community should require a common machine-readable passport from CARICOM nationals, and also agreed that the use of machine-readable passports should be supported by a regional immigration network linked to various databases pertaining to criminals.
General Counsel, can you just remind us as to when that meeting was?
Right, so yes, Also on page 366 of the record, that meeting was on the 8th to 9th of November 2004, and the decision is on page 366 of the record. Consistent with the view that there is a need to balance freedom of movement with adequate security measures is the preamble of the Pass Treaty, which appears on page 372 of the record. If your honors would look at 1, 2, 3, 4, 5, 6, the 7th preambular paragraph, the contracting parties recognizing the need to balance freedom of movement of persons in a single domestic space with adequate security measures through a secure and trusted pass system. So when heads in relation to the passport insisted on a machine-readable passport, it was to ensure that there was a secure and trusted passport system. And the same thing with the carry pass system. And one cannot say that a driver's license, which is not machine-readable, is a secure and trusted system which will maintain the requisite balance between the right to freedom of movement and the right for member states to maintain public order and security. So unless your honor wish to hear me further, those are the submissions of the Caribbean community.
Just a minute, before you conclude, you're saying that one of the grounds on which neither the voter's ID card nor the driver's license should be regarded as a sufficient document is the fact that neither of them is a machine-readable document. Is that your submission?
Yes.
In the
Your Honor.
context of the need to balance appropriate security considerations against the rights of CARICOM nationals.
Yes, Your Honor.
Yes.
Because with a machine-readable passport, an immigration officer can see relevant information concerning the passenger. But with a driver's license, it provides no information. So it renders the exception in the Shanique Myrie case useless. OTOs are nugatory, however we may wish to express that. Because that right, as your honors are very well aware, that right to an automatic stay of 6 months is subject to the CARICOM national not being an undesirable. One cannot determine if a person is an undesirable by the mere looking at a driver's license. So that is why our driver's license, in the opinion of CARICOM, is not an accepted form to invoke, an accepted travel document to invoke the automatic right of 6 months. And also, the actual decisions of CARICOM indicate that they have accepted just the CARICOM passport, and that is the CARICOM passport, and that can be seen on page 367 of the record, which my learned friend, who's appearing on behalf of the applicant, noted, where the conference agreed that the CARICOM passport will be accepted as evidence of community nationality and as such evidence of entitlement to rights granted under the revised treaty. And some member states took quite a long time in order to utilize the additional stocks of old passports, and it was recognized then that it could not simply be said that a CARICOM passport is, that only holders of a CARICOM passport would be entitled to the automatic 6 months, but also holders of national passports issued by CARICOM member states. And that reference to holders of passports issued by CARICOM member states being entitled to the automatic 6 months can be gleaned from the decision of the conference at its 34th meeting, and that appears on page 368 of the record, where strongly reminded member states to ensure that the holders of the passport issued their CARICOM member state are granted an automatic 6-month stay in accordance with decisions of the conference. And Haitians are using their passport. Their passport is not the specific CARICOM passport with a logo, but they're using their passport to invoke their right to an automatic stay of 6 months, subject to the exceptions that should be married.
And all these passports are machine readable.
To the best of my knowledge, but the emphasis was on passports need to be machine readable.
Yes. And
I would think, yes.
And
because
when they are machine
if it's-
readable, then that is the way you will get additional information to decide whether the person may be a genuine, present, sufficiently serious threat, as we defined it, the court
Yes.
defined it in
Yes.
Myri.
Yes, to the fundamental interest of society. Yes.
Yeah, so
Yes, Your Honor.
through that system, you will get extra supplemental information about the person, which will assist the custom officials to make that judgment.
Yes, Your Honor. And if I may turn to Article 6 of the CARIPAS Treaty, which appears on page 375 of the record, it is stated in Article 6 that the CARIPAS system shall be operated in conjunction with the BMS, and BMS has been defined in the treaty to mean for the management systems and refers to the independent database-driven systems deployed in the contracting parties specifically to assist immigration authorities in capturing and monitoring travel movements occurring at authorized ports of entry and exit. And if you look for that, the same paragraph states, so the CARIPAS system shall be operated in conjunction with this BMS, APIS, the Advanced Passenger Information System, ACIS, the Advanced Cargo Information System, and watch list or other security systems which may be agreed upon from time to time. So the defect with the driver's license is that it does not meet the threshold of providing the requisite security.
Yes, but the question, of course, is also then if this system is necessary component of the system, why has it not been implemented? Can you say anything about that?
Yes, Your Honors. So the reason advance was that certain monies were to be paid to impacts. The monies were not paid, and now the system is outdated. So although heads are looking for means to enhance security in the region, the actual machines that were purchased are now out of date. So another mechanism would have to be found if so desired.
Okay. Something which might not be completely relevant to the case, but it was mentioned, and I just want to know from you about this Article 32, paragraph 5A2, which seems to equal residents or belongers to nationals. But you have stated, CARICOM has stated that, this is actually, as I understand it, has always been meant to be limited to Montserratians. And you refer to a decision of the conference December, I think, last year, so quite recent. Of course, this will have, the interpretation of that particular part of the article will have further consequences for other cases. So if you can say anything more about it, I would appreciate that.
All I can say, Your Honor, is that we are currently drafting the amendment to this article to ensure that it is limited, so that it reflects more clearly that it is limited to Montserratian nationals. That's all I can say. I was informed, and it's not sufficient, but that was informed that it's because Montserratian nationals do not belong to an independent CARICOM state, an overseas territory. So that language was put in to accommodate the demonstrations, but is now being taken out of context. So
Yeah.
hence I recognize that it is important to make it clear what the original intention was.
So it was always the intention, and you want to make it even more, the member states want to even make it more clear that, for example, a resident of a CARICOM country will not be entitled to the core rights in Chapter 3. Is that what you're saying?
Yes, Your Honor.
Okay. Thank you very much.
Right.
Okay, thank you.
Yes, thank you very much, Mrs. Bab Schaefer. Mr. Ferguson, do you have any reply?
No, just briefly an observation permitted to make. But the emphasis seems to be now on machine-readable passports and machine-readable forms of identification. So, of course, enhance security, and that is understandable, indeed commendable. But the issue of freedom of movement for CARICOM nationals, it means all of these machine-readable documents, and those, to the best of my knowledge, are relatively recent. My learned friend from Ghana did indicate that the national passports, not the CARICOM machine-readable passports, those are also machine-readable. I do have my with regard to that, and it just brings me back. It brings me back to the issue of the aim of CARICOM in a step-by-step process, always to enhance freedom of movement while ensuring the balance of proper security mechanisms are in place. But the issue of freedom of movement predates all of these issues, and it comes back ultimately to the question of, can a CARICOM national who enters a third state, a fellow CARICOM state, if he is in a position to show that he is a CARICOM national or citizen, should he then be treated automatically, because he does not have the requisite documents, in a manner that leads to great expense, to embarrassment, and otherwise, as the applicant has been subjected to, simply because he does not have that document that CARICOM says is conclusive of nationality, which is the passport, and I would accept. So the difference that between our position and my learned friend's position, while I appreciate and understand the rational advance to ensure that security measures are in place, but it certainly does not address the issue, CARICOM having introduced freedom of movement, really, whether it is the intention to deny ordinary citizens of our region the privileges simply based on the absence of particular documents.
Mr. Ferguson, just a question which occurred to me. On your theory, let us suppose that your client had adduced enough evidence to satisfy immigration officer, for example, that he was a Grenadian national. His entry into Trinidad would still have to be documented, would it not?
His entry?
Yes.
my lord.
So how would that be documented? Would it not be by a stamp in a passport?
Yes, my lord.
And what passport would
And,
the stamp be inserted in?
In this case, the legitimate travel documents that he had in his possession would be the U.S. passport. That's the travel document. But as I indicated, my lord, our submission is that the mere fact that he was traveling on a United States passport.
No, I
does not
think we have that. I'm just puzzled by the conundrum. That stamp would be indicative of his right to move freely within the community. But that stamp would be affixed to a passport which doesn't give any evidence that he has a right to move freely within the community.
Yes, well, it will be established based on the other documents that he has in his possession. And while I accept that the place of birth on the U.S. passport is not sufficient necessarily to say that he is currently a Grenadian citizen, but by the cumulative documents in his possession, it confirms that he is a dual citizen of both the United States and CARICOM. And that's the issue here. So one does not take away the other. If it is accepted that because he was traveling on a U.S. passport, then automatically he is not entitled to any CARICOM rights because he merely entered on the passport. That would ultimately, in my own respectful view, be saying that, listen, dual citizenship is not a concept that is recognized, which is really not so. So that would be the view. As a CARICOM national, he's entitled to freedom of movement. I accept, as my learned friend indicated, that it is not absolute, just like even constitutional rights are not absolute. It's not absolute, and we are not arguing that it's absolute. Or the only issue here is really verification that Mr. Bain is also a CARICOM national. And the fact that his passport is stamped, his U.S. passport is stamped, does not take away that fact. So what it means, he becomes entitled to the best of both worlds. That is what simply dual citizenship means. If I go to the United States, I'm a U.S. citizen, I'm entitled to the rights and privileges that exist in the United States. If I come to Grenada, whether on a U.S. passport or otherwise, I am still a Grenadian citizen and I'm entitled also to those rights and privileges. One does not adversely affect the other. That's the essence of our submission.
Yes, well, thank you.
Much obliged.
We will take time to consider and we will inform you of when we're ready to give a written decision in this matter.
Much obliged.